I'm Eric Lanigan with Lanigan&Lanigan, attorneys in Winter Park, Florida. I'm going to talk for a minute about some fundamentals of Chapter 11 bankruptcy. And generally speaking, Chapter 11 bankruptcies are usually associated with businesses. You'll read about if an airline goes into bankruptcy, it's almost always a Chapter 11 because, as you notice, they don't disappear, they keep operating. That's what Chapter 11 is somewhat all about. Chapter 11 can also be used by individuals because Chapter 13 bankruptcy, which is for individuals who want to reorganize their debt and enter into a payment plan, has certain ceilings of maximum amount of debt that you can have in a Chapter 13. And if you go above that ceiling, then you're going to have to go into Chapter 11, which is more complicated, more hands-on. So let's talk about a few fundamentals of Chapter 11. I think the one thing that probably gets everybody from a major airline right down to a small business into Chapter 11 is they become aggressively hounded by certain creditors, and they don't have the ability to pay them, and those creditors have the ability on any given day to put them out of business by levying on property, garnishing bank accounts, and they're out of business. And if you represent creditors, you're always concerned about racing to the money, because the second creditor to get to the pot of gold finds that the pot of gold is empty. So the creditors will typically be racing to see who can get to the money first and be very aggressive. And that's when a Chapter 11 comes into play, because when you file a Chapter 11, if somebody said, what's the most fundamental thing that happens? I would say my answer would be that creditors lose their individual collection rights. They're no longer individual creditors. They are now dealing with the bankruptcy estate, which is operating for the benefit of all creditors. So the business continues operations, and all similarly situated creditors are treated the same. So there's no longer this creditor being highly aggressive and they're going to put me out of business tomorrow. No, they're not, because now they're under the control of the bankruptcy court and they're all treated collectively. And when the bankruptcy is filed, just like a Chapter 7 bankruptcy for an individual or a Chapter 13 bankruptcy, in Chapter 11, an automatic stay or automatic freeze goes into effect. All collection activity instantly stops. Literally, if someone files a bankruptcy and they're loading the cars up on the tow truck to take them away, they have to stop, put them down. So everything stops, and basically the purpose of that is to give the debtor some breathing room to try to get things reorganized without getting things picked up, bank accounts garnished each day. You can't operate a business in that manner. So the automatic stay goes into effect. Everything stops. Another fundamental issue of Chapter 11 bankruptcy is what we call the debtor in possession. And where the debtor in possession comes about is if a company were to go into bankruptcy and the bankruptcy law was written such that immediately some outsider, a court-appointed trustee, is going to come in and run the business, there's two real problems with that. First of all, that's a very expensive proposition, especially if you get into larger companies. That they're already in Chapter 11 because they're cash strapped. So the last thing on earth the business can afford is to bring in a whole new management team that's very expensive. The other fundamental point is that if that were to occur, not only would it be expensive, prohibitively expensive, but it would probably almost certainly cause the business to immediately collapse, because all the relationships between existing managers and customers, existing managers and employees would all be gone. And this trustee or management team would be coming in an almost impossible situation, and I think would virtually doom any business that was forced into that position. Therefore, the law keeps the existing owner management team in place to operate the business as what they call the debtor in possession of the business. Now, they run under court oversight and supervision. Basically, they run the business for the benefit of the creditors, subject to the court's supervision. The debtor in possession, they run the business, they examine the creditor's claims, and they even decide which claims they think should be paid and which ones should be opposed in court. A debtor in possession can be removed for cause. It has to be fraud, dishonesty, or gross mismanagement. Not just mismanagement, gross mismanagement. That's a heavy burden in any type of legal situation. So there's a good likelihood that if the debtor in possession follows the basic rules, does the basic reporting, that they will stay the debtor in possession and continue to operate the business throughout the course of the Chapter 11 bankruptcy. Sometimes there can be a middle ground where the court would appoint what is referred to as an examiner. It's not somebody brought in to run the team, but someone to come in to do an in-depth review or examination of the debtor in possession activities and to report if they find anything untoward or that should not be going on. So you hate to say it to a client, but the bottom line was, if you'd only been here a year ago, when all of this litigation started going bad, and realized that it had to get cut off and get this into a different court, none of that would have happened. But because it was too late, we're stuck in a straitjacket, and basically the case was almost completely doomed from the beginning. So don't wait. If the business is going south, get into a lawyer's office who knows something about Chapter 11. Discuss your situation. Determine whether or not it's time to file. Or if not, what can be done to avoid or to deal with the creditor and possibly even to avoid filing a Chapter 11. And again, I'm Eric Lanigan, Lanigan&Lanigan, attorneys in Winter Park, Florida.